In the case of Jenny versus Hoover School District, there is the question of whether or not a student-led prayer before school lunch every day is unconstitutional or not. Only about 3/4 of the student body participated, and the staff neither joined or tried to prevent it. Jenny finally sued the school after enduring an entire year of daily prayer in the lunchroom of Hoover High School. What the court needs to decide is whether the Establishment Clause of the First Amendment has been breached. The answer? Yes. In 1985, the Supreme Court made a decision regarding prayer in school. The case Wallace v. Jaffrey has substantial ties with our current case. Alabama state law has authorized a 1-minute period of silence or prayer for all students and staff before the school began every day. The court decided that this was a violation of the First Amendment since the state's purpose was to endorse religion and that it did not continue the idea of religious neutrality. Even earlier than that, in 1962, the court had voted a voluntary prayer in school as unconstitutional. In the case of Engel versus Vitale, the state of New York issued a morning voluntary prayer before class every day. The Supreme Court declared this also as unconstitutional because the state of New York was promoting the religion by giving out the prayer. If we go back another 12 years, we find the case McCollum versus Board of Education in 1940, which was brought to the court because the school was having religious education classes in the school classrooms. Students who did not participate had to go to other places in the building to continue non-religious studies. The U.S. Supreme Court announced this unconstitutional yet again, stating that the use of tax paid for classrooms was a violation, along with the fact that students were supposed to be attending classes and that this religious education was taking part of it away. Through the years, the separation of church and state clause has been tested repeatedly. However, from the previous cases, we can infer that because of the precedents, a group prayer, whether involuntary or voluntary, is considered unconstitutional. The fact that it was a student-led prayer has no effect on the outcome. Jenny was forced to endure the prayer that violated her basic rights. She couldn't leave during lunch, nor should she have to. It was a public school lunchroom, which therefore means the separation of church and state clause should apply there. The school administration's lack of involvement ties in with the previous Wallace versus Jaffrey case, since the school failed to remain religiously neutral by allowing Melissa to force her prayer upon the student body. I highly doubt that if a student KKK member stood up in the lunchroom one day and started preaching about white power and the righteousness and value of lynching, that the staff of Hoover High School would do nothing and let that student speak daily for an entire school year. At least I hope not. In the McCollum versus Board of Education occurrence, the court ruled that since the students' time for secular studies were being encroached upon by the religious ones, that the religious classes are unconstitutional in a public school. Melissa's daily prayer during lunch took away time from other students to eat and socialize without religious matter interfering. Jenny's rights were infringed upon, and she deserves to be compensated. If the Supreme Court disagrees and declares Melissa's daily lunch prayer as constitutional, then the whole precedent of at least 75 years crumbles. It would mean that yes, you can force your religion upon fellow classmates and staff members in a public building of education. Yes, you can take away others' time for different non-religious activities. And yes, schools can endorse one religion over another despite specific wording in the Constitution about government needing to remain religiously neutral. Those are only a few of the possible future ramifications that could occur if Melissa wins this case and gets to continue leading some of the students in prayer.